I believe the honourable member for Kamloops Thompson Nicola would like to stand on a question of privilege.
Thank you, Mr. Speaker. It's always a pleasure to rise on behalf of the people from Kamloops Thompson Nicola, though today I rise for the second time, I believe, in my time as a member on a point of privilege. And I don't know that members really relish rising on a point of privilege because it means that something has gone astray in the process. So, Mr. Speaker, I rise based on an event that occurred on July 28th, 2025. I was with the member for Cloverdale Langley City, and I visited Fraser Valley Institution, which is a women's facility in the Abbotsford area. The interference amounted to, I believe, an obstruction interference with my ability to fulfill my parliamentary responsibilities or our parliamentary responsibilities, and therefore a breach of parliamentary privilege ensued. On July 28th of this year, my colleague and I attended the jail, a correctional facility operated by the Correctional Service of Canada, in the exercise of our rights as parliamentarians under Section 2 of the CCRA, Corrections and Conditional Release Act, which provides that, quote, every member of the House of Commons, every senator, and every judge of a court in Canada has the right to A, enter any penitentiary, B, visit any part of a penitentiary, and C, visit any inmate with the consent of the inmate, subject to such reasonable limits as are prescribed for protecting the security of the penitentiary or the safety of persons, end quote. This tour or visit had been arranged with uniformed union correctional officers who were representative of the Union of Canadian Correctional Officers. However, on arrival, we were informed that we would be accompanied throughout our visit by the one of the institution's assistant warden, Chris Saffron. Mr. Saffron advised us that he was personally instructed by the institution's warden to accompany us throughout our visit. Now, it's important to note here, Mr. Speaker, that Mr. Saffron actually told the member and I that he is not trained in security. He is not in uniform. In other words, he has no use of force interventions that could protect anybody, including a member of Parliament. He said, I'm here because I'm told to be here, Mr. Speaker. In fact, it came back that this was a security issue at one point when we were speaking with the staff through my office. That was my understanding, Mr. Speaker. Mr. Speaker, I have conducted dozens of penitentiary tours to date, and I have never been informed of a requirement to be escorted by a correctional service executive, Mr. Speaker. And I'll pause here to say this. As a member of Parliament, as a human being, as somebody whose job it is to supervise what is happening, that's why the power in Section 72 is there, I have never been treated so disrespectfully by anybody in my time as a member of Parliament as I was by Assistant Warden Chris Saffron. I could not believe the level of disrespect he showed to myself and the member from Cloverdale Langley City. I couldn't believe the condescension. He was questioning why we were there, what we would possibly have to do there, and how could he possibly be getting in the way of us doing our job. Well, I'll tell you how he was getting in the way of doing our job. When people see an assistant warden, they don't necessarily want to talk to members of Parliament. They fear talking to somebody. And this includes inmates, and this also includes staff members. We are there for the protection of those inmates. Some people may not believe it, but we actually are. We are there to watch firsthand. So somebody claiming that they have to shadow us, is this Wayne Gretzky in the playoffs in the 1990s where somebody has to shadow him at all times? Because the reality, Mr. Speaker, is the reason they want to do this, in my view, is so that they can get ahead of the next scandal that we will be breaking. I asked to speak to the warden to discuss this sudden, unexpected development. I was informed that she was unavailable. There was nothing going on in the jail that would preclude this, and I've never heard of a warden unavailable to speak to two members of Parliament. I asked for a supervisor, and we were told he didn't have their numbers. Mr. Speaker, this is obviously untenable and just an inappropriate situation. And when you couple it with the disrespect, it does amount to an intimidating environment. The assistant warden dismissed our concerns, interrogated us about the purpose of our visit, and what we were, quote, looking for. Mr. Speaker, it is not for anybody to get in the way of what a member of Parliament is looking for or not looking for or wishing to see. We need to be able to do our jobs without encumbrance, without somebody shadowing us that could intimidate staff and inmates alike. The fact that somebody did this showing gross disrespect and unprofessionalism at such a high level, it's as though this person was congratulated, Mr. Speaker, because I actually wrote a letter to the Correctional Service of Canada Commissioner. It took a very long time to get a response back talking about Mr. Saffron's behavior, and the Commissioner didn't even address it. It's as though this person did the right thing by being disrespectful to members, Mr. Speaker. Mr. Saffron admitted that there were no safety concerns posed by our visit, which were not adequately addressed by the scheduled presence of 2 uniformed officers. In other words, the assistant warden's presence was surplus to requirements. The discussion with staff and inmates, which I'd hoped to have, among other things, inform my work as official opposition shadow minister for public safety, including the preparation of oral and written questions here in the House of Commons, the development of motions for studies at the Standing Committee on Public Safety and National Security, and researching lines of questioning of witnesses appearing at committee. However, the assistant warden's unprofessional behavior, aggressive tone, authoritarian demeanor, and lack of cooperation seriously led me to believe that there may well have been something at the institution which the Correctional Service of Canada senior leadership do not want us to see and did not want us to see on July 28th, or wanted to know what we might see so they could get ahead of these things, Mr. Speaker. Certainly, the presence of a senior institution executive on our time at the jail put a damper on the flow of conversations we had during that visit. In short, Mr. Speaker, the assistant warden was there to mind us, to inhibit and to intimidate the free and candid views of staff and inmates being shared with parliamentarians from the official opposition. This conduct amounts to obstruction and interference to fulfill my parliamentary duties. House of Commons Procedure and Practice, 3rd edition, at page 111, explains that, quote, a member may also be obstructed or interfered with in the performance of his or her parliamentary functions by non-physical means. In ruling on such matters, the Speaker examines the effect of the incident or event had on the member's ability to fulfill his or her parliamentary responsibilities. It is impossible to codify all incidents which might be interpreted as matters of obstruction, interference, molestation, or intimidation, and as such constitute a prima facie case of privilege, end quote. On February 20, 1984, Mr. Speaker, Francis found a prima facie case of privilege concerning allegations that official in the office of the President of Canada Post informed an employee of Albert Cooper, the official opposition critic for Canada Post, that questions about Canada Post asked in the House of Commons had to be cleared through the President's office, or else any future assistance or cooperation for Mr. Cooper would be withheld. At page 1560 of the debates, the chair stated, quote, a threat emanating from any government department or public corporation to withhold information or cooperation from a member of Parliament would undoubtedly hinder that member in the fulfillment of his or her parliamentary duties and therefore constitute a breach of privilege. By the same token, an offer of favorable treatment on condition that questions are first cleared with the same office, with the office concerned, would also violate privilege in an equally fundamental way, end quote. I believe that the circumstances in my situation are sufficiently analogous, Mr. Speaker. I would also address an earlier ruling on July 15, 1980 at page 2914 of the debates, where Madam Speaker Sauvé ruled that a distinction must be drawn between the parliamentary work which members of Parliament conduct and the many political and constituency-related duties we undertake. To be sure, Mr. Speaker, my visit and the interference which I experienced fell squarely in relation to my parliamentary duties rather than those of other categories of an MP's work. Parliamentary Privilege in Canada, second edition, explains at page 222, quote, "For just as the member is protected in what he does during a proceeding in Parliament, so must the member's parliamentary work or work relating to a quote, proceeding in Parliament be alleged to be improperly interfered with before the Speaker may find a prima facie case," end quote. As I mentioned earlier, Mr. Speaker, I'd hoped to inform my work this autumn in the House of Commons as the official opposition's lead spokesperson on issues related to corrections, among other topics, and as a member of the Public Safety Committee of this House, work which indeed would lead to a proceeding in Parliament. I stress this point, Mr. Speaker, because it is an important aspect to distinguish from the matter which was before Mr. Speaker Lamoureux when he ruled on April 29, 1971, at page 5338 of the debates concerning members' access to penitentiaries, a subject which, at the time, I should add, was addressed only through directives of the Commissioner of Penitentiary as the position was then known, rather than an Act of Parliament as it is today. I had access to Fraser Valley Institution on July 28. That is not in dispute. My question of privilege, rather, concerns interference with my parliamentary work related to proceedings in Parliament. The concept of proceedings in Parliament lacks a clear-cut, black-and-white definition of its scope. Bosk and Gagnon, for their part, explain at page 90 that, quote, "there is no statutory definition in Canada." End quote. In turn, the authors refer to how the concept has been fleshed out in our sister parliaments. The United Kingdom's leading authority, Erskine May, explains at paragraph 13.12 of the 25th edition, quote, "The term proceedings in Parliament has received judicial attention, bracket, not all of it in the UK, or in the United Kingdom, sorry, close bracket. But comprehensive lines of decision have not emerged, and indeed it has been concluded that an exhaustive definition could not be achieved. The primary meaning of the proceedings, as a technical parliamentary term, which had at least as early as the 17th century, is some formal action, usually a decision taken by the House in its collective capacity. While business which involves actions and decisions of the House are clearly proceedings, debate is an intrinsic part of the process which is recognized by its inclusion of the formulation of the article of the Bill of Rights, 1689, close bracket. Not all proceedings require debate. A motion for an unopposed return on which there is no debate is held to be a proceeding. An individual member takes in part a proceeding, usually by speech, but also by various recognized forms of formal action such as voting, giving notice of motion, or presenting a petition or a report from a committee," end quote. Further down in that paragraph, we continue to read that, quote, "On a number of occasions, the House of Commons or committee has endeavored to elucidate this very broad understanding. The Selection Committee on the Official Secrets Act in 1938-39 argued that, quote, proceedings, end quote, covered both the asking of a question and the giving of a written notice of the question. After considering the scope of the protection, the committee concluded, quoting, cases may be easily imagined of communications between one member and another, or between a member and the minister so closely related to some matter pending in or expected to be brought before the House that, although they do not take place in the chamber or a committee room, they form part of the business of the House, as, for example, where a member sends to a minister the draft of a question he is thinking of putting down, or shows it to another member with a view to obtaining advice as to the propriety of putting it down or as to the manner in which it should be framed," end of the indented quote. The conclusions of this committee were later agreed to in the House, end quote. More recently, the UK Parliament's 1999 Joint Committee on Parliamentary Privilege wrote at paragraph 12 of its first report, quote, "Proceedings are broadly interpreted to mean what is said or done in the formal proceedings of either the House or the committees of either House, together with conversations, letters, and other documentation directly connected with those proceedings," end quote. At paragraph 113 of the same report, the Joint Committee assessed that, quote, "Drafts and notes frequently precede speeches and questions, and members often need assistance and advice in preparing them. By necessary extension, immunity accorded to a speech or question must also be available for preparatory drafts and notes. For instance, from a research assistant, it would be absurd to protect a speech but not in the necessary preparatory material. This principle must also apply to drafts of speeches, questions, and the like, which in the event are not used. A member cannot always catch a speaker's eye, or he may change his mind," end quote. Many of the conversations which I'd hoped to have at Fraser Valley Institution on July 28th were or would have been directly connected to my potential parliamentary proceedings this autumn. The individuals I interviewed during my visit were providing me with assistance and advice in relation to matters I had under consideration at that time. And Mr. Speaker, I would pause here to note that even previously when I've gone to penitentiaries, when they didn't know I was there, when the management didn't know, they literally, through ATIP, I found out they followed me with their cameras to see who I spoke with. What are they hiding? What are they so afraid of? And what are they trying to get in front of or deal with here, Mr. Speaker? Elsewhere, Australia has legislated its parliamentary privileges and assigned the following definition to proceedings in Parliament at subsection 16, sub 2 of the Parliamentary Privileges Act 1987. Quote, "All the words spoken and acts done in the course of or for purposes of or incidental to the transacting of the business of a House or a committee, and without limiting the generality of the foregoing includes sub B, presentation or submission of a document to a House or committee, sub C, the preparation of a document for purpose or of or incidental to the transacting of any such business," end quote. More recently, New Zealand also legislated on parliamentary privileges, following a court decision which related to the extent of parliamentary privilege available to public servants supporting ministers with question period preparation. New Zealand mirrored Australia's statutory definition at subs 10 and sub 2 of its Parliamentary Privilege Act 2014. Mr. Speaker, the reality is that we as members of Parliament have to know what's going on. And the presence of management, especially when there's an acrimonious relationship that's well documented between guards or correctional officers and their managers, or with inmates who may not want to be anywhere near a manager, inhibits my ability to speak with that person. We need to be able to do that completely in private and completely respected. The uniformed correctional officers have always been completely respectful in that regard, given us just the ability to do our jobs. It's no surprise that Mr. Saffron acted the way he did. I've watched the work of Commissioner Ann Kelly, who didn't even respond fulsomely to that letter. And we've seen that we have been stymied, that I have been stymied in doing my job as a critic, and more concretely, as a member of Parliament, just as anybody on the government bench would be permitted to do. At the end of the day, we need to do our jobs without harassment and without anybody following us and watching what they can see, so that the government, be it the minister, be it Commissioner Kelly, or be it Mr. Saffron, can know what we're up to. In summary, Mr. Speaker, the assistant warden of Fraser Valley Institution, at the instruction of the warden, who wouldn't talk to us, if not more senior management in the Correctional Service of Canada, obstructed and interfered with my ability to prepare fully for proceedings in Parliament this autumn. That amounts, in my view, to a breach of the established privilege to be free from obstruction interference, intimidation, and molestation. Should you agree, Mr. Speaker, I would propose a motion to refer the matter to the Standing Committee on Procedure and House Affairs. Thank you, Mr. Speaker.
I thank the member for his intervention, and I will come back to the chamber after studying what he has said today.
Impels.
To rule on the question of privilege raised on September 15th, 2025 by the member for Kamloops, Thompson Nicola, concerning members' access to federal penitentiaries. In raising the question of privilege, the member alleged that he and the member for Cloverdale Langley City had been obstructed and treated disrespectfully during a visit to Fraser Valley Institution on July 28, 2025. He argued that Section 72 of the Corrections and Conditional Release Act was enacted to enable members to supervise what is happening in penitentiaries. He also explained that this visit was made to fulfill his responsibilities, including his role as the opposition shadow minister for public safety. The member admitted that he was granted access to the institution, but he asserted that the constant presence of an assistant warden, which was imposed despite his explicit request to visit the facility with uniformed correctional officers only, inhibited his conversations with staff and inmates by creating an intimidating environment and preventing candid discussion. The member stated that this obstruction interfered with his ability to fully prepare for the proceedings of the House, including the development of questions and motions and lines of questioning at committee. On September 16th, the member for Cloverdale Langley City rose in support of her colleague's allegations. She pointed out that members have a duty to directly oversee public institutions to ensure that incarcerated persons are treated with dignity and respect. Pour sa part, le secrétaire parlementaire.
On September 18th, the parliamentary secretary to the Leader of the Government in the House of Commons responded. He stated that there was no clear connection between the member's visit to the penitentiary and their parliamentary duties. He noted that this visit was not officially sanctioned by the House of Commons or by a committee. While the parliamentary secretary acknowledged that it was regrettable that the members believed that they were not treated with due respect, he added that there were likely protocols in place to have visitors escorted. Since the members were allowed to enter and tour the facility, no intimidation or obstruction took place, in his view. Before going any further, I believe it is appropriate to review the wording of Section 72 of the Corrections and Conditional Release Act, which the member for Kamloops, Thompson Nicola, referred to. It reads as follows. Every member of the House of Commons, every senator, and every judge of a court in Canada has the right to, subject to such reasonable limits as are prescribed for protecting the security of the penitentiary or the safety of persons. They thus have the right.
And to judges, incidentally, is nothing new. In the United Kingdom, these visits are believed to have canonical origins that date back centuries. In Canada, they are mentioned in the legislative provisions from before Confederation, as well as in Parliament's 1868 Penitentiary Act. At the time, the right to visit was granted not only to members of Parliament, but also to many public office holders, including the Governor-General, the Lieutenant Governors, the members of the Federal Cabinet, and others. These visiting rights remained in place thereafter, set out in various laws before being repealed in 1961. Parliamentarians' visits to federal penitentiaries subsequently fell under a directive of the Commissioner of the Correctional Service. Visiting rights were restored to statutory form in the current Section 72 of the Act with the overhaul of the prison law in 1992. Note that while the bill was before Parliament, an amendment that would have given parliamentarians full access to any person in a penitentiary at any time was debated. However, the House rejected that proposal and passed the current wording. In a ruling delivered on April 29, 1971, concerning a member who had been denied access to a penitentiary, which can be found on page 5,338 of the debate, Speaker Lamoureux offered the following explanation, and I quote, On a number of occasions, I have defined what I consider to be parliamentary privilege. Privilege is that which sets honourable members apart from other citizens, giving them rights which the public do not possess. I suggest we should be careful in construing any particular circumstance which might add to the privileges which have been recognized over the years and perhaps over the centuries as belonging to members of the House of Commons. It seems to me that the fact that the Penitentiary Act in the past, until 1961, I believe, did provide for a right on the part of members to make visits is an indication that if it were part of parliamentary privilege, it would not have been included in the statutes." End quote. Les droits de visite des pénitentiaires.
The right of parliamentarians to visit penitentiaries provided by Section 72 of the Act does not seem to fall within the bounds of parliamentary privilege. Consequently, the way members' visits to institutions are handled is not a matter for the chair. As for the allegation of obstruction by the assistant warden, in the decision handed down on February 26, 1975, which can be found on page 3580 of the debates, Speaker Jerome stated the following, and I quote, "The classic definition of a question of privilege does not fit circumstances in which a member in his duties outside this House finds that his scope is being restricted or attempts are being made to restrict his scope of intervention and effective work on behalf of not only his constituents, but his point of view as a member of the federal parliament," end quote. As a House of Commons Procedure and Practice 3rd edition explains on page 60, and I quote, "Privilege essentially belongs to the House as a whole. Individual members can claim privileges only insofar as any denial of their rights or threat made to them would impede the functioning of the House. In addition, individual members cannot claim privilege or immunity on matters that are unrelated to their functions in the House." End quote. It further states the following on page 109. Quote, "While every member has duties as a representative of the electorate, a member may claim the protection of privilege relating only to his or her parliamentary functions, though the line distinguishing these duties might blur." End quote. The threshold that must be met to find that a member was impeded in the performance of their parliamentary functions is intentionally set high. And the associated repercussions must be more than hypothetical. Not every activity that involves members' access to information necessarily meets this threshold. Merely stating that the information could be useful for a motion a member intends to move or a question they wish to ask is not enough to link it with House proceedings. The issue must be closely and directly related, or necessarily incidental, to the legislative or deliberative functions of the House or its members.
Furthermore, as regards the protection of members against obstruction in the performance of their functions, I would refer to the words of Speaker Bosley in the decision rendered on May 16, 1986, and printed on pages 13,361 and 13,362 of the debates, in which he remarked that a threat or attempt to intimidate cannot be hypothetical. It must exist or have taken place. Therefore, the Chair cannot find that there is a prima facie question of privilege. I understand the members' concerns, and I'm not downplaying their importance, but the facts presented do not satisfy the strict criteria for finding a breach of parliamentary privilege. That said, while this matter does not constitute a prima facie question of privilege, our federal institutions, including penitentiaries, must nonetheless strive to facilitate the vital work of parliamentarians. I thank all members for their attention.